Good morning. First, I want to begin this first meeting Oxford Girona by give thanks all the present for your assistance and giving the welcome to the Oxford professors.
Thank you.
We want that this meeting be the first but not the last one, and this is the intention of the Girona professors. We begin the meeting with the Professor Gardner. John Gardner is Professor of Jurisprudence in the University of Oxford, and his last book was Offences and Defences. For me, the most relevant property of the Professor Gardner is his special sensibility to the items of the philosophy of private law. I hope that in the future, the philosophical point of view to the private law will be as relevant as the philosophical point of view to the public law. And I am sure that part of this change will be relationship with the work and the challenge of the Professor Gardner. But today we return to the philosophical public law. Yes, with this paper. Can there be a written constitution? Professor?
Thank you. Thank you very much. And thank you all very much for coming. And like the Girona professors, the Oxford professors, and indeed our colleagues who are speaking tomorrow, would like to make this a more regular event. Very much a pleasure to be here, and we hope you'll come back and see us in Oxford. Now, as for private law and public law, I agree with you. For many years I've written about criminal law, not only about criminal law, but often about criminal law, and I've always rather regretted this, because I felt that I was writing what other people wanted me to write about, and it's nice that you want me to write about private law. But this paper is actually unique in all the work I've done, because it's about what you on the continent would call the non-criminal part of public law. Yes, it's about constitutional and administrative law. And for me that's a unique departure, and I think it may be unique in my whole career. I may never write anything else about constitutional and administrative law. But I wrote it mainly because I was asked to give a public lecture to celebrate some special occasion at the Southern Methodist University it's in Dallas, isn't it? In Texas. And I wanted to really horrify the students with a really extreme question, which they would find counterintuitive. So I thought I would challenge them to think about whether the American Constitution, as they knew it, really was a constitution. For somebody coming from the United Kingdom, that is a live question, because we obviously are educated in a different constitutional tradition, and we think of it as a very strange thing that anybody should have their constitution written down. In fact, from our education, this is not just a strange thing politically, but a puzzling thing conceptually. We are puzzled, and much of our homegrown general jurisprudence shows why we are puzzled, that it should be possible that a constitution should be written down. So that's really what the paper is about, or one of the things the paper is about. Actually, when I was looking over it, I realized there were many other things the paper was also about. So let me just mention a few things that the paper is trying to do for different audiences, so that there'll be something in this for everybody. So one thing that the paper tries to do is to teach people some British law. Actually, mostly some English law, although there's a little bit of Scottish law in there as well. But by and large, the law that is taught in this is English, and this is, I hope, of general interest, especially for people who didn't know about our Constitution. I did a very daring thing and taught some Americans a little bit of American constitutional law, also in the third section, when I was talking about the amendment provisions. It turned out that quite a lot of my American students had never heard of this, and so they were surprised. I thought this was quite fun to, as we say in English, bring coals to Newcastle, take bits of American constitutional law to America, and teach it to American students. So that's one of the tasks of the paper, is to teach some law, mainly English law, but then a little bit of American law, and a little bit of Scottish law as well. And then there's also at the end of the paper another topic which opens up in front of us, which I regarded as subsidiary, and actually I'm less interested in, but which many people are more interested in, so I thought it would be interesting for them if I said just something about it. And this is about the interpretation of constitutions, understanding what they mean. And so at the very end I give this a few pages, and this is smuggled in by asking the question, could a constitution be entirely written? Because by that time we've established that it could be written in the sense that matters for the rest of the paper. But could it be entirely written, I ask, and this is just a little provocation at the end so that we could talk, if some people wanted to, about what constitutions mean. So that's another topic. But the main parts of the paper really bring together two sets of questions, which are different from both of those. One set of questions is about the nature of law, and in particular the organization of law into systems. And it inherits a conceptual apparatus from Herbert Hart, which involves thinking about the structure or the systematization of legal systems in terms of some rules that have to be there for the legal system to be a system and to be legal as well, but mainly for it to be a system. And these are rules of recognition, change, and adjudication. And so one of the major aims of the paper was to try and sort out the relations among these different types of rules, why they have to be there, and what the implications are of them being there. And that interrelates with the other more official topic of the paper, which is to try and understand better what the difference is within public law between constitutional and administrative law. And to say what makes some part of the law constitutional. Or, to put it in the way that it would be presented in the New York Review of Books, what makes it the Constitution? Because I take that to be a very similar question. I should mention, I don't take the question, what makes this constitutional law, to be identical with the question, what makes this the Constitution? Because I mentioned several times, to ward off misunderstanding, that there are parts of every constitution that are not law. And this is another thing that's particularly apparent to British lawyers, English lawyers and Scots lawyers especially, I think, who have grown up with the idea that some parts of the Constitution are not legal parts of the Constitution. And I am always in the paper reminding my reader to take account of that. And it becomes actually important in trying to assess the place of Hart's rule of recognition in the Constitution as the paper wears on. Because as I explain, Hart was in doubt, and I think he was rightly in doubt, about whether to classify the rule of recognition as a legal rule. And for some purposes and on some occasions, it seems right to do that, and it seemed right to Hart to do that. But for other purposes and on other occasions, it seemed wrong to do that. And I thought that was interesting, but I wanted to make clear that that didn't show that the rule of recognition was only doubtfully part of the Constitution. It's possible for the rule of recognition to be a conventional rather than a legal part of the Constitution. So I didn't say that because I was asserting that that was the case. I said that to make clear that that was an option that was open. And the mere fact that we were in doubt about whether the rule of recognition is legal didn't show that we should be in doubt about whether the rule of recognition is constitutional. So I'm saying that because I wanted to show that there wasn't an exact match between the question, what is the Constitution, and what is constitutional law. Not an exact match, but a close connection. And I took my question, what is the Constitution, to be best tackled by trying to distinguish constitutional law from other parts of public law. And although I didn't say very much about administrative law, constantly through the paper I had in mind that there's a distinction somewhere between the bit of public law that we study under the heading constitutional law and the bit that we study under the heading of administrative law. And I was trying to work out what kind of distinction or distinctions might be at work there and what we might be assuming. And I introduced the distinction in the very beginning of the paper, very crudely indeed, and in a way that later in the paper gave me much cause for regret. But that's all right, the paper is like that. It's a series of self-amendments, like constitutional authorities can self-amend. I can self-amend as the author of my paper. I make progress through the paper and I refine by a series of steps my initial thoughts about what makes law constitutional as opposed to administrative. So when I introduce it, I say that the Constitution is made up of rules that specify the major institutions and officials of government and determine which of them is to do what, how they are to interact, and how their membership or succession is to be determined, and so forth. Meaning, things like that. And so the key category there that seems to distinguish constitutional from administrative law would be major institutions and officials of government, I suppose, as opposed to minor institutions and officials of government. Not a very felicitous way to think about the problem, as it turns out. It turns out that there are many more important things about the distinction than the distinction between major and minor, which is why in the first paragraph I introduce various hesitations and doubts. I say these rules, without which there would be no legal system, or some of them, in combination with some other rules, all these indeterminate categories are already creeping in because I'm trying to anticipate improvements in the way I think about my own subject matter as the paper goes on. So that's all very crude, and it works well for the purposes of the first section because, as I mentioned, the first section introduces some law and helps us to see some bits, especially of English law, and how they work. So that's really all I was trying to do at the beginning, and it really is only a bit later that I start to complicate the matter and, in the process, to introduce some new distinctions. So here are some of the thoughts that I do introduce in the first section, using English law as a vehicle. I introduced the thought that the United Kingdom Constitution contains no procedure for its own deliberate amendment, right? And then that raises the question, so how does anything come to join the United Kingdom Constitution? If there's no procedure in our Constitution for changing it, how come things become part of it? Ever? How did they ever become part of it if they couldn't be deliberately put there by anybody changing it? So that's a question which I answer by explaining that there's in the constitutional dialectic of the common law systems, and especially in the United Kingdom, there's an interplay of the way that law is made and the way it's received. And I, at this stage, float the idea that it's the way that law is received that makes it constitutional and not the way it's made, since there is no procedure for deliberately making it that way. I should stress that there are procedures for signaling that you intend it to be made that way. So just recently, our government passed a big, grandiose piece of legislation called the Constitutional Reform Act. And I'm happy for them to say that if they like. But I want to say back, just wait and see. Just wait and see. It'll be a Constitutional Reform Act if it turns out to be a Constitutional Reform Act. If not, then not. And whether it's a Constitutional Reform Act is going to depend on the way it's received by other people. And I stressed the people concerned to be law-applying officials, not only the courts, but you might think in the end, led by the courts. Led by the courts, because the courts will make authoritative decisions which will overrule or override decisions made by other law-applying officials, like immigration officials and police officers, and so on. So this picture, you might think that it's a very British picture, is of the Constitution being created as a constitution by the law-applying officials, not because they made the law. The law, let's say, was made by legislation, but it was received as constitutional legislation in some, but only some cases, and maybe the signal that came from Parliament was that this is how it should be received, but it was still open to the law-applying officials to argue and to decide that Parliament had not succeeded in making the Constitution any different. So that was a theme from English law that I wanted to introduce at the very beginning. And that I wanted to introduce at the very beginning because I wanted to use it to lay the challenge against other constitutional traditions. I wanted to say, well, why shouldn't this be thought to be true everywhere? In other words, couldn't it be argued, as I said at the beginning of section 2, that in every jurisdiction and at every time, what really determines the status of some law as constitutional law or as part of the Constitution is how it's received by its official users, principally the courts. Never mind whether it has constitutional stamped on it at the time when it's issued. And this is my way of, as I put it in the paper, turning the tables So whereas my American students would always say to me, oh, you guys don't have a constitution because there can only be a written constitution, I'm now saying to them, well, actually, a written constitution is the problem case because you have to explain how it became the written constitution, and you can only explain that by an unwritten constitutional doctrine, a doctrine according to which these are the law-applying officials, and they're the ones who decide what counts as the written constitution. So your constitution, as you like to call it, the written constitution, say, of the United States of America, is a piece of legislation that has been judicially or by other law-applying officials endorsed as the constitution. And so this opens up the possibility that it really, apart from that law-applying or reception activity, slips back into the same sort of law as everything else. And so might turn out just to be administrative law. This is the big threat that hangs over my American students, that I'm going to discover that the President, the Supreme Court, the two houses of Congress, that they're going to turn out just to be the equivalent of Oxford City Council or of the Financial Services Authority. They carry certain delegated powers. I'm always keeping that risk alive for my readers, and it comes back several times. So that's how the paper gets its question going, by taking a piece of law from the British context and then throwing it out at other legal contexts and asking why shouldn't this be thought of as a more general proposition, namely that the law of the Constitution is always selected as the law of the Constitution by what we might call common law methods. I leave open which common law methods because there are plenty of different common law methods. There's customary law, there's case law. These are different, but nevertheless they're common law methods. They give the control to the law-applying authorities, and the question is why not think of written constitutions as created as constitutions in as much as they're received that way in case law and customary law. So this forces me to come clean and to state more precisely what I think the distinction is supposed to be between constitutional and non-constitutional public law. And I give a formulation which is still very tentative on the bottom of page 11 of the copy that's available on SSRN. And I distance myself from it by putting it in my own past. I say, as a student of UK constitutional law, I mean 24 years ago, I was given to understand, but since I can't remember anybody telling me this, I add, or maybe I just came to understand by myself, that the distinction between questions of constitutional law and questions of ordinary public law, also known as administrative law, lies in the type of institutions that these respective parts of the law regulate. Administrative law regulates institutions whose powers are delegated, and constitutional law regulates those that do the delegating. That's to say, institutions whose powers are not delegated, but as it's sometimes put, are inherent or original. I was a little bit hesitant about using these words inherent and original because they're used for many other purposes as well. For example, in the American Constitution, the notion of an original jurisdiction means a trial jurisdiction, whereas to English ears an original jurisdiction means a non-delegated one. And for me this was a hard question of translation, but I tended, for that reason, from time to time, to use the negative form, not delegated, to remind people that when I was using these technical terms, inherent or original, it was the not delegated feature that I was trying to draw attention to. So it was a delegated, not delegated contrast, and this is my first attempt to formulate in a more precise, technically satisfying way what might be going on here. And I was, you can see why this might have contributed to my general project of making my audience anxious, because if it were the case that the President or the Supreme Court or the Houses of Congress enjoyed their power because they'd been given it by the courts, including the Supreme Court, but other courts too, and the police, and other law-applying bodies, if that was the way they'd become to be thought of as the authorities, then you might think this put them in the delegated rather than the inherent class. And I spent most of the paper trying to complicate and problematize that thought and show that it didn't follow from what I had said at the beginning about the way in which constitutional authorities might acquire their power from their constitutional power from the law-applying officials, that it was delegated. It didn't follow from that. It just sounded like it was going to follow. And so some time in the paper was spent distinguishing I suppose, a number of different questions about the relations between different kinds of authorities. So one kind of question I put on one side were what I thought of as merely historical questions. It's interesting to reflect that the power of the courts in the United Kingdom, and way back in the United States as well, is an emanation of the power of the Crown, the absolute power of the Crown, because the courts were royally appointed. And if you were asking a historical question, you would think that every court must be a delegated authority. After all, that's how it came to be a court, through an act of delegation. But I pointed out that isn't the same as understanding the law. The law may defy history in the way it now is normatively organized. That your power was delegated to you doesn't mean it's a delegated power. It's a delegated power if it's in law a delegated power. That's to say, if the source of your authority is treated now as being as being a delegated source. So what would be an example of that? Well, the High Court in England has been created by many interesting historical acts. Going way back, it was a royal delegation that travelled the country solving disputes. Then there was a counter delegation sent out by the King's Chancellor, creating what we later came to know as the Courts of Chancery. And then there were a series of judicature acts in the 1870s when Parliament tidied all this up and allocated certain tasks to these courts, now combined. And but latterly, the courts didn't care about any of this. I mean, let's say the courts don't say, let's look up the judicature acts, or let's look up the royal warrant to find out whether this is our job. No. They say, we're the High Court, and we have inherent jurisdiction. And they determine for themselves, I have some hesitation about this formulation as well, but they determine for themselves which cases are their cases. So there's some discussion of the difference between law and history there, some brief discussion. There's also an attempt to show that not every authority relation that holds between different parts of our governmental system is a delegation relation. This is actually in lots of ways more complicated, but I try to show that a power that is not delegated isn't for that reason not subject to restriction by other bodies. A lot of constitutional law is about détente or comity, as my colleague Timothy Endicott calls it, where there's a certain amount of deference between different constitutional bodies, and it can become to be recognized by even a body of inherent jurisdiction that there are limits to what it may do, and that those limits are regulated by law, and that's because they fall under another body's authority, and these things can all come to be accepted and lived with and form part of the law without it coming to be the case that either of these bodies is now enjoying delegated authority. And this turns out to be quite complex, and I spend quite a lot of time in the paper trying to explain how a relationship in which one party can restrict another's powers isn't the same as that one party giving the other party its powers. So that's another distinction that's at the heart of the paper. So all of that is designed to show that not everything that people imagine in their rather physical representation of legal systems is actually seen in the same diagram, that not every hierarchy is a hierarchy of delegation, There are historical hierarchies, there are hierarchies of overruling, but the hierarchy of delegation is a different one and may have to be represented separately. And so it doesn't follow from the fact that the law-making powers of Parliament, for example, or the executive authority of the President, that these things are held subject to the judgment of the courts. It doesn't follow that these things are delegated by the courts. This is important. This is the first, if you like, the first major concession handed back to the written constitutionalist. I'm saying just because it's the courts that get to decide that this is part of the Constitution, don't think for that reason that it's a delegated authority and therefore not really part of the Constitution at all. That would be a non sequitur. But that's not all I have to contend with, right? Because I also have to contend with an interesting feature of the American Constitution, which is not unique, which is what you might call a backstop legislative power to control what have always been thought of as constitutional authorities. Now, this is quite interesting. It's a legislative power, and it creates all sorts of worries for us. It's the power to convene a constitutional convention to amend the Constitution using a different authority, namely the Constitutional Convention, from the ones that are thought of from day to day as constitutional. And to make matters worse, it's arguable that it's the same authority that made the Constitution, namely the one that came together in Philadelphia at the end of the 18th century. And if it is, then the thought might be, well, actually, although it's not the courts that are delegating power to Congress, the President, and so on, so they're not administrative law authorities by that route, still they're administrative law authorities, because there is a super legislator, admittedly in abeyance, of whose authority the President, the Supreme Court, and Congress are delegates. And that authority, that supreme super legislator, could give, but he could also take away, was the thought. And what's more, the mere fact that it couldn't take away didn't stop these authorities from being delegated. It's a further and deeper worry. Okay? It couldn't take the powers away because it was abolished, but still they might legally be delegated. And that would put them on the wrong side of my proposed dividing line. So there are two ways to deal with this. Well, three ways actually. I could have said they're not constitutional authorities. The President, he is after all just Oxford City Council writ large. That would be one possibility. I could say that the authority of the President is not delegated and wasn't given to the President in the relevant sense by the convention in Philadelphia, isn't regarded in law as having been given by the Philadelphia Convention. This is difficult. Or I could say I had the wrong test for what counts as constitutional. And in the end I said I had the wrong test. Right? I modified my test. So no, it's not, strictly speaking, right to say that the authority, the constitutional authority is inherent or original or non-delegated, whereas administrative authority is delegated. Some delegated authority is constitutional authority. It only has to be irrevocably delegated. So there's a kind of delegation which can be regarded in law as delegation, but is still to be regarded as consistent with the delegatee being a constitutional authority, and that is irrevocable delegation. And so this leads me to much pain when I was trying to do it, to try and understand a real piece of American law, namely whether there really was a condition of irrevocability built into the amending powers in the Constitution, whether the convention that established the constitutional position of the President, Congress, the Supreme Court in the 1780s was the same convention that could be re-established under the Constitution now for amendment purposes. If it was, whether it could be what they sometimes call a roaming convention, that's to say one that could open up the whole question again, or whether it had to have a specific subject matter. All of these interesting questions. I didn't resolve these questions, and I was pleased not to resolve them because I discovered that they have no legal resolution. This is very happy. They are left indeterminate because of a very interesting, one could hardly call it a conspiracy, but an interesting collective will, perhaps, in the American constitutional institutions not to reopen this question. And so there's an indeterminacy in the law of the United States about what that convention would be, were it ever, I might say per impossibile, to be brought back together. And that was nice and fun, but that was really a digression, because I was interested more in illustrating the way that the non-revocability feature should be understood. Now, I wanted just to say a little thing that's not in the paper at this point, because one of my esteemed colleagues in Oxford, my friend Nick Barber, over-interpreted or attributed to me stronger positions than I held when he was reading this bit, and thought that I was saying that it's part of the nature of a constitution that it has to be entrenched. Now, I didn't say that, right? I said that inasmuch as it's part of the constitution, as part of the constitution is regulation or recognition of delegated authorities, their authority has to be irrevocably delegated. So if there is part of the constitution with that structure, there has to be a kind of entrenchment. You do have to create a system of constitution making that can't be constantly revisited. And that's why in the South African case, well, in numerous other cases of modern constitution building, transitional authorities were created, the point of which was that they would wind themselves up at the end of the constitution making process, because that way the delegation could be rendered irrevocable. But that was a very localized kind of entrenchment. Concerning inherent jurisdiction, I didn't claim that there had to be any kind of entrenchment. I don't think it's true that in the United Kingdom, for example, the inherent authority of the Crown to deal with matters of, which are called royal prerogative matters, like the signing of treaties and the making of war, is entrenched in any way. And in the paper I exemplified that by pointing out that as soon as Parliament legislated on these matters, by normal legislation, they were regarded as having fallen out of the royal prerogative. So this is a case of a constitutional authority, inherent constitutional authority, mind you, which is not entrenched. It's only the other kind of constitutional authority, the kind that's delegated but can't be withdrawn, that has to be entrenched. And that explains why we might associate constitutions with entrenchment, but we don't need to have a comprehensive doctrine of entrenchment to understand or to find the limits of the Constitution. All right, so that is how I rescue the American Constitution from oblivion in legal terms. There's a jurisprudential story going on which is laced into this, which is about the rule of recognition. So the rule of recognition is problematic for everybody in this story. Why? Because Hart argued, and I think he was right to argue, that you can't legislate a rule of recognition. That the rule of recognition has to be made by practice, by somebody's practice. And he gravitated towards the view, although he didn't commit himself very firmly to this, that the relevant practice was the practice of law applying officials, as he sometimes put it, mainly the courts. So he put the rule of recognition in the position of being unlegislatable. And I sketch out some considerations in the paper which show why he thought that, although he never expressed it very clearly, I don't think. This created a nest of problems for believers in written constitutions. There was a huge confusion in the law review literature in the United States about how the rule of recognition is related to parts of the Constitution. Some people trot out the thought that the rule of recognition is in the Constitution, which would instantly violate Hart's conceptual constraint on it, namely that it can't be in a constitution like that. It can't be written down like that. Of course, some people who say that may mean it's not in the written constitution, but in the unwritten constitution, there are lots of difficulties in interpreting the literature. Kent Greenawalt did quite a lot, I think, to sort some of this out. He didn't get everything entirely right, but I try in the paper to give some credit to Kent for having a very thorough and a well-informed goal at trying to understand how the American Constitution and similar written constitutions might relate to what Hart called the rule of recognition. And one of the main difficulties with the working out of this is that there are some difficulties in working out the relationship in Hart's own work between rules of recognition and the other kinds of rules that have to be there for a legal system to exist, the rules of change and adjudication. And Jeremy Waldron recently wrote an article that I spend some time on in the paper, trying to argue that at least some of these rules must be redundancies. They must collapse out. They must just be the other rules. A rule of recognition is just more of the rule of change and adjudication, or vice versa. What are all these spare wheels for, Jeremy asks? Why don't we just let there be rules of change and rules of adjudication, and let the rule of recognition just be another name for them? After all, says Jeremy, the whole point about powers is that they change duties. Why does that matter? Because the people who have the power are identified in the rules of change and the rules of adjudication. Our duty to follow them is supposedly provided by the rule of recognition. But if they have the powers, they're giving us duties. So the duty must, as it were, be presupposed. And so a presupposed duty surely is in the very rules that presuppose it. And I argue that that's not true, that the duty-imposing rule may be presupposed by the power-conferring one, and the power-conferring ones may be presupposed by the duty-imposing ones. All of that may be true, but it doesn't mean that they're the same rules, that you still need to fragment these into the rules that create the duty and the rules that create the powers. And I illustrate that using a debate that Hart had with an imaginary Kelsen. I say it's an imaginary Kelsen because it was Hart's slightly muddled rendition of Kelsen based on poor material that he had available to him. But this is the debate about how to understand the rules of the criminal law, whether you should understand every offence and its sanctions as adding up to just one norm, or as fragmenting into two. And Hart said it had to be two. There had to be a rule that was addressed to the subjects and another rule that was addressed to the officials, and they, even though they entail each other, he couldn't understand one without knowing that the other was there. It would be in some way incomplete, logically incomplete, I think he thought. Nevertheless, there was more than one rule there. And I used that as a lever to try and argue against Waldron, much the same point in the constitutional context, namely that just because the rules entail each other, we shouldn't assume that they're the same rule. And why does that matter? It matters because it leaves open the possibility that the rules of adjudication and change can be in the written Constitution. They can be in the Constitution of the United States of America, that thing that gets handed around, without the rule of recognition being there. The rule of recognition can be outside that bit of the law. And as I sometimes put it, perhaps incautiously, above that bit of the law, meaning giving us a duty to follow that bit of the law that's in the Constitution, including the rules of adjudication and change that are in it. Waldron's argument would have the effect that if the rules of change and adjudication are there in that document, then so is the rule of recognition, which according to Hart's analysis of what a rule of recognition is, can't be true, because a rule of recognition can't be in legislation. Or if the rule of recognition isn't in legislation, as Hart said it couldn't be, then it would follow that the rules of change and adjudication couldn't be in the legislation either. They would also have to be customary, and so they couldn't be found in the United States Constitution, considered as a document, either, which would mean that we were back to our problem of regarding the president as a city council or a colonial governor or something like that, as to say not really a constitutional authority at all. So that was the connection then between all that stuff about the rule of recognition, the rule of adjudication, and the rule of change, and the more doctrinal discussions about the American Constitution, the British Constitution, and how they differed. So in the end, I rescued the American Constitution, similar written constitutions, from constitutional oblivion by a series of interlocking moves, some of them just refinements of my own grasp, my own student grasp of what a constitution does and is. That was my crude attempts at the beginning, which were gradually reformed through the paper. And then there was also the second jurisprudential and I think transcendental argument which said that such and such a thing, if it's like this, can't be part of this. If it's as Hart says it is, it can't be part of the Constitution. How do we save it as part of the Constitution from that fate? And I tried to explain how we could by distinguishing the rule of recognition from the rule of adjudication, or the rules of adjudication, and change. And so in two different ways, by two convergent strands, not always clearly distinguished, I resuscitated the written constitution as a non-oxymoronic possibility. No surprise there, you may say. All I did was stand up for the obvious. But that's good. I mean, I always think that, in my work at least, I spend a lot of my time standing up for the obvious, and I leave the controversies to other people. I'm much more interested in trying to make sense of why such and such, which is obviously the case, is the case. And this is another example of the same, perhaps over-philosophical interest in obvious things. So thank you very much.
Thank you.